Hi, welcome to this week's discussion on Pretrial Procedures, Chapter 10. Let's talk about the steps to trial. So how do we get there? Well, first, officers have to have probable cause. Then they make an arrest. The defendant then goes to booking, then charging, arraignment, and pretrial hearings. So we're going to look at those a little bit more closely. Let's talk about arrest. Arrest is what actually starts off the criminal process. This is what officially puts someone in the criminal justice system. After a person is arrested, law enforcement writes out and files what's called a complaint. And that is a part of the police report that tells the prosecutor what the person did and what the facts are that the officers have observed or gathered as a result of their investigation. They then sign an affidavit that states they are swearing to all the information in it, and these are typically attached to arrest warrants and search warrants, and they must show probable cause. So after a person is arrested, they go to booking, and booking is where the person is entered into the local and state and federal databases. So the person has to go through formal paperwork. They are fingerprinted in some states and some areas. They do a cheek swab, and then that person's DNA is tested for DNA that is within the system for cold cases. And it's typically a quick release. The person is either released on their own recognizance or with a different kind of bond. Let's talk about the charging decision. Now, after booking, and after the police have generated their police report, that police report goes to the prosecuting agency. Back in the old day, they used to physically drop off hard copies of their police reports that included their complaints and affidavits. Now, most places are electronic, so that just gets sent over to the prosecutor's office. And then the prosecutor has to decide what crime, if any, they're going to charge. Oftentimes a police officer will arrest someone for a specific offense, but a prosecutor will look at that and say, you know what, I don't think this is just an assault. I think we had a theft that occurred too, so really I think we should charge this as a robbery. So all charging decisions are made by the prosecutor, and it really is a critical decision, and it's one in which prosecutors have a lot of discretion. Prosecutors have the freedom to not charge it, which is kind of like a dismissal, I guess. There are also having difficulty speaking today, 4 prosecutorial policies in terms of charging. And really it's more like what methodology do prosecutors use to charge crimes? One way they do it is by legal sufficiency. And what that means is when they're looking at the complaint and the police report, they will look for legal sufficiency, meaning is there evidence of each and every element of the crime? Because ultimately that's what the prosecution is going to have to prove should this go to trial. So they'll look for legal sufficiency. And if there's evidence cited by police for each and every element of the crime, then they can charge it. If it's a misdemeanor, the prosecutor can charge it. If it's a felony, it's got to go to a grand jury. Another methodology they use is looking at trial sufficiency. What are the odds of conviction? If the odds of conviction are good, then the prosecutor will charge it. If it doesn't look like they'll be able to get this past a jury, then they will choose not to charge it. Another methodology they use is system efficiency. And system efficiency is how do we get these cases moved very quickly? This is very much in line with the criminal justice approach, that whole conveyor method. So oftentimes in systems efficiency, they tend to either charge what they think they can charge, what they have legal sufficiency for, and they move it very quickly. Another way they do system efficiency is to divert, and diverting specifically first-time offenders to some kind some kind of diversionary program that keeps them out of the criminal process by not formally charging them. Okay, and it also helps reduces the workload. If you don't charge as many cases, then you're not going to have as many cases to prepare for and ultimately try. And finally, the last methodology used by a lot of prosecutors is defendant rehabilitation. And they look at what is it going to take for this person to not commit another crime. And so typically new offenders get diverted. You see this a lot in juvenile systems where you have first-time offenders that rather than be charged and placed in the juvenile system, they are sent to a first-time offender program where if they do everything they're supposed to do, the charges get dismissed. What are some factors affecting the prosecutor's charging decision? Well, they like to avoid uncertainty, and they typically only want to charge the cases that they can prove. Now, whether or not that's legal sufficiency or whether or not they think they're going to get a guilty verdict, that decision, varies greatly from prosecutor to prosecutor. Prosecutors are also, as I said a moment ago, looking for convictability. How likely is it that the person's going to be convicted? If there's some evidence of each and every element, but some of that evidence is probably going to be suppressed, well, maybe that's something you don't want to take to trial because you're not going to really be able to prove it in the long run. What are some other factors? Well, does the suspect have a criminal record? If they have a pretty substantial criminal record, then oftentimes prosecutors are going to charge it if they have the evidence to back up the charge. Other times they're going to look at the victim. Is this victim someone that requires justice? Or is this a victim that might not be believable for some reason? Other times they're going to look at, downstream organizations. What's the likelihood of success? How is the case going to be evaluated? Not only by judges, but by the jury. What's the climate of the community? In a lot of jurisdictions recently, a lot of prosecutors' offices have stopped prosecuting possession of marijuana under 2 ounces simply because the communities don't want to deal with them. They feel, the community as a whole, feel like it's kind of a waste of time and energy and money. Okay, and other times they do it based on perception and unfortunately some stereotypes. But these are all things that prosecutors think about when determining what to charge and whether or not they should charge at all. What are some constraints on prosecutorial discretion? Well, discretion is not unlimited. Prosecutors, again, are held to a higher standard. They have to see that justice is done. So when they decide to charge, it has to be because of the evidence of the crime, not because of the defendant's race, religion, or some other arbitrary classification. Okay, they have to be able to prove what they're charging. And there's also due process of law. Prosecutors cannot charge someone just to be vindictive. They can't do it for political reasons. Your book talks about a prosecutor, Mike Nifong, and he ended up going after several lacrosse players for Duke University. If you're not familiar with that case and you want to read up on it, I highly suggest you do. It's a very, very good example of a prosecutor abusing his discretion. And eventually he was stripped of his law license and ability to practice law as a result thereof. Okay, and also, professional standards of conduct. The prosecutors do have a right not to charge. They don't have to. But they do have a professional responsibility to only charge what they can prove and to not do so as a part of, vindictive prosecution or to further their career. Let's talk about information and indictments. These are the formal charging instruments that come out of a prosecutor's office or grand jury. So information. Information is in states without a grand jury, and in some states that have grand juries, like Texas, it's used for misdemeanor crimes. So in Texas, a prosecutor can charge any misdemeanor by information just by the prosecutor signing it. And just to reiterate what your book said and what the law is, only the federal government requires grand jury. Other grand jury requirements are done on a state-by-state basis. Indictments. Indictments come from a grand jury. They are constitutionally required for the feds and in those states that require them. And what an indictment says is that a grand jury has reviewed the police report and they have determined that there is sufficient evidence for trial. Okay, and again, the grand jury looks at all the evidence and they decide whether to true bill or no bill. A true bill means that they are formally charging the person with the offense. A no bill means that they are not going to charge the person and they're essentially going to decline the case. Your grand juries typically are composed of an average 23 people. Texas has 12. Usually for felony or federal charges, they are closed proceedings in which the prosecutor goes into the room with the grand jurors and explains the case. It is supposed to be a check on overzealous prosecutors so that people from the community can determine whether or not the prosecution has enough evidence to go forward, and they issue a true bill or a no bill. Now, in my experience, when I was doing this, if you have, as a prosecutor, if you have a good relationship with your grand jury, they more likely than not will agree with your opinion. You know, typically when I laid out the evidence and I said, I think this needs to be charged, they charged it. And there were times when I looked at it and said, you know what, this is what we have. I don't think it's enough to go forward. However, you look at it and you decide. And more often than not, they went with my recommendation. So after a person is booked and they're arrested, booked, and formally charged, or even before they're formally charged, they have an initial appearance. And that occurs after arrest and after booking. Now, sometimes it's done before charging, or after charging, but most time it's done before charging. And it has to be done without unnecessary delay. Each state has their own rules in place on how quickly this must happen. It's got to be 48 hours in Texas for misdemeanors and 72 for felonies. At this initial experience, the judge explains their rights. They're offered a chance to plea, and they're also typically given their chance for bail. So let's talk about bail. What is it? Bail is, if you ever played Monopoly, it's what you got to pay to get out of jail. And that's typically the only way you will get out. There is another way, and we'll go over it in a second, but it's basically you pay money to get out of jail. And the judge is the one that decides whether or not to allow bail, because bail is not required. What is required is you can't have excessive bail. The courts have said no excessive bail. And there are different factors that the courts consider to determine what is excessive. You look at the person's ties to the community, their criminal history. Are they likely to be a danger to themselves or a danger to others? What's the likelihood that they're going to abscond and not return to court? So all those things are taken into consideration as whether or not to grant bail and what amount to set it at. There are different types of bonds. So bonds are what you pay to get out. There's the cash bond. Cash bond, if someone's got $1,000, their bail is set at $1,000 and they pay a cash bond. That means they pay all $1,000, and when they show up to court and the case is disposed of, they can get that back. The most common is a surety bond. That is the bail bonds office, where a person, or usually their relative or loved one, goes to a bail bonds, secures a loan, and the bail bond puts up the bond and the person is released. The final kind is called a personal recognizance bond, and that's where the person signs a PR bond and they promise to come back to court, and they are released upon their signature and promise to come back. Now, it sounds really good, but PR bonds come with a lot of strings attached. It's almost like being on probation, because they are given a PR bond officer who puts a lot of stipulations in place. They'll have a curfew usually. They've got to call and check in. They're not allowed to go to certain places like bars and adult establishments. And so there's a lot of restrictions put in place for PR bonds. I recommended typically that if a client could afford it, to pay the cash bond because they weren't going to have all of the restrictions that they would have of a PR bond. So after a person gets out, now they're going to have their formal arraignment. An arraignment is where a judge formally tells the defendant of the charges. The charges are read in open court, and the defendant has a chance to enter their plea. 99% out of the time, they plead not guilty. Okay, they can plead guilty at arraignment. It's not, doesn't happen very often. Most defense attorneys will just enter a plea of not guilty for their client so they can investigate the case. Defendants can also stand mute where they refuse to say anything. At that point, the judge just enters a not guilty verdict for them. They can plead nolo contendere, which is no contest. They can do an Alford plea. This isn't done in very many states, and parents, if any of you are parents, you're familiar with this. Alford plea is where the defendant says, okay, I'll go ahead and plead, but I didn't do what you're accusing me of. You know, if you've got kids, how many of you have heard that? Well, fine, I'll go ahead and take your punishment, but I didn't do it. That's an Alford plea, and typically not very many states allow that. Pretrial motions. So after the person has gone through the arraignment, we will now go to pretrial motions. And the defense and prosecution file these motions, and there's numerous motions. These are only a handful of them. Motion to dismiss charges, motion for discovery. Usually that's put in place by the court. They'll just enter a discovery order and the prosecution has to turn over everything. You know, not only do they have to do so, turn over all exculpatory evidence, but there's other things they turn over too. That's generally just part of a automatic court order. Oftentimes defense will file a motion to suppress, meaning that they feel that the police violated their client's rights somehow. You know, whether they're trying to suppress evidence or a confession or the arrest itself. Okay, sometimes people are tried together, so a defense attorney will file a motion to sever, meaning that the defendants are tried separately. Motion to determine competency, so whether or not they feel that their client has a mental disability and they shouldn't be prosecuted at all, meaning they won't understand the proceedings. Motion for change of venue if they feel their client won't get a fair trial. Judges' rulings. I can tell you that for the change of venue, the attorneys for the Walmart shooter here in El Paso did try to change the venue, and that was denied. Judges' rulings. That's going to set the boundaries for the case, and the judge is going to say, okay, people, here are the rules for the case, and everybody's got to play nice and follow my rules. Plea bargaining. Plea bargaining really is all about negotiation. Most convictions, upward of about 90%, stem from guilty pleas. And why is that? Because it's not possible to try every single case that's charged. It would take 15 to 20 years to try cases if that were the case. You know, really only about 1 to 3% of cases that are filed actually go to trial. In the 1960s, you saw a rise in plea bargaining, and you also saw a rise in professionalism, and both sides recognizing that they wanted to minimize the caseload and get rid of cases that needed to be disposed of. There are cases that get filed, and you know, even if you had enough to charge it initially, sometimes you can't find witnesses. You find out witness credibility, at least on the prosecution side, isn't there. Evidence gets stale or doesn't look as good on paper, or doesn't look as good in reality as it did on paper, and so some of those cases get dismissed. Other times, the defendant, there's so much overwhelming evidence that the defense attorney looks at it and says, you know what, he's going to be found guilty anyway, might as well try to get the best deal I can for my client. And oftentimes they try to negotiate on charge reduction. So, hey, rather than plead to a felony, can they get it to a misdemeanor? Can they get lesser requirements on probation? Can they get lesser term in jail? You know, all those things that they can deal with and talk about for plea bargaining. Okay, so let's talk about defining plea bargaining. It all involves guilty pleas. And allocution. The defendant has to explain to the judge what happens and sometimes admit the crimes. In felonies, the prosecutor will give a summary of what occurred or what's being alleged beyond what's in the indictment and give a little bit of facts to support it, and the defendant will have to acknowledge it and admit to it. In sentencing agreements, the prosecution and the defense attorney, they agree to the terms and conditions of probation or to the days in prison or a combination thereof. And then the judge has to either accept the sentence or the judge can refuse to accept it and not allow a plea. Sometimes the judge will allow a plea, but the defendant will change his mind and they'll have to allow a withdrawal of the plea. And, sentencing agreements, while it does help move things along, it does limit judicial discretion because often the agreement is come to between the prosecution and the defense, and the judge does not hear about it until an agreement has been reached. But the judge does have ultimate say as to whether or not they are going to allow the plea to proceed. Sometimes you have ad hoc plea bargaining, and defendants will make unusual concessions. Maybe they don't want to attend family violence counseling. Maybe they'd rather do like a inpatient substance abuse because they feel like that's the root of the issue, and prosecutors can agree to it. There's all sorts of different things that you can do in a plea bargain. They can agree to an extraordinary condition of probation, like shock probation. They do 20 days in jail and then they come out and finish probation. There's all sorts of things that can be done. What are some arguments for and against plea bargaining? Well, for, it's efficient. It's an easy way to get a conviction, and oftentimes, sometimes plea bargaining involves, if there's a victim and they're owed money for property damage, you get the defendant to pay the restitution to the victim and you dismiss the case, so the victim is made whole. It also helps limit caseloads because prosecutors and defense attorneys can get bogged down with cases, and again, you want to do what's best for the victim. What are some arguments against? Well, sometimes defendants feel like they have no choice. They plead guilty because they can control the sentence, and they're scared about what could happen if they're found guilty at trial, and they have no control over what happens to them punishment-wise. Maybe they can get probation in a plea agreement, but they're looking at jail time if they go to trial. And sometimes prosecutors overcharge because prosecutors know that they're going to have to negotiate. So it's just like car dealerships where they price it really, really high, and they know that people are going to try and negotiate that price down. Well, prosecutors sometimes charge the highest thing they can just to have some wiggle room in negotiations. There have been some attempts to restrict and ban plea bargaining. Sometimes the judge will institute cutoff dates. There will be jury waivers, but for the most part, plea bargaining is integral to our criminal justice system because otherwise we would be at a complete standstill with cases waiting to go to trial. What are some of the predictors of plea bargaining? And one of the biggest ones is the question, does race matter? There's really a lack of research in this area. A lot of criminal justice programs around the country are looking at this and gathering statistical evidence, but what they've found is that it's really based on socioeconomic. So if a defendant has a fair amount of money, they're more likely to get a much better outcome than someone who is poor. Ladies and gentlemen, that's all I have for you today. I hope you have a great rest of your day. Thanks so much.